Welcome to U.S. Immigration TV. Well, in this video, I'll answer and discuss two common questions people have when they apply for a tourist visa or what's called visitor visa or B visa. Number one, can I apply for a visitor visa if I am under petition? And number two, can I visit the U.S. on a tourist visa if I am under petition? Well, surprisingly, the answer to both questions is yes, but. In other words, it is perfectly legal and allowed for a person to apply for a visitor visa and even visit the U.S. even if they are under petition by a family member or an employer. However, I have to caution you that there are some requirements and restrictions. So make sure to watch this video until the end to determine if you could possibly be eligible or qualified to apply for a visitor visa or visit the U.S. even though you are under petition. Now, first, let's discuss how and why it's legal to apply for a visitor visa even though you're under petition. The Foreign Affairs Manual, or FAM, are the regulations that consuls refer to and follow in connection with issuing visas. You know, it's sort of like the Bible for the embassy. One of their regulations specifically authorizes issuance of a visitor's visa even if a person is under petition. Now, that particular FAM, or Foreign Affairs Manual, regulation that consuls follow states, and I quote, "You may issue visitor visas to applicants with IV or immigrant visa applications pending or with IV petitions pending with the U.S. Citizenship and Immigration Services, which is USCIS. You must be satisfied that the applicant's intent in seeking entry into the United States is to engage in activities consistent with B1, B2 classifications for a temporary stay, and the applicant has a residence abroad which they do not intend to abandon. While an active immigrant visa application or petition is reflective of an intent to immigrate, unless you have reason to believe the applicant's true intent is to remain in the U.S. until such a time as an immigrant visa becomes available, and here's the important part, you may issue the visa if the applicant is otherwise qualified," unquote. So as you can see, consuls are authorized to issue visitors' visas to people who are under petition, provided they are otherwise qualified. Okay, well, what does otherwise qualified mean in connection with eligibility for a visitor visa? Well, the first requirement is that the person must have a residence abroad, which means, according to the FAM, the person's principal actual dwelling place in fact without regard to intent. In other words, does the person who's applying for a visitor visa have a home outside the U.S. where they live and where they intend to return after their visit? The next requirement for a visitor visa is the person must, and I quote, demonstrate permanent employment, meaningful business or financial connections, close family ties, or social or cultural associations, which will indicate a strong inducement to return to the country of origin, unquote. In other words, does the person have an established good life where they live such that they will want to return after their visit to the U.S. rather than, having nothing to go back to? They have poor employment prospects such that they may be tempted to perhaps remain in the U.S., get a job, and work under the table, things like that. That's what you have to show will not be the case with a consul. And then the third, and perhaps the most difficult and confusing requirement, is proving their intent in connection with visiting the U.S. And here's the thing, eligibility for a visitor visa is all about a person's intent or what's going on in their mind. By law, Under U.S. immigration law, everyone applying for a visitor visa is presumed to want to immigrate unless they can prove otherwise to the consul. In other words, a person is effectively guilty until proven innocent. A person goes into the embassy for their interview for a visitor visa with the presumption that they want to go to the U.S. and overstay, and it is up to the person to prove to the consul that is not the case. That is where they need to show that they have permanent employment, meaningful business or financial connections, close family ties, etc., in their home country or wherever they happen to be living at that time. So see, many people applying for a visitor visa are simply unable to overcome this presumption and are refused their visa regardless of the reason that they want to go to the U.S. So let me give you a couple of examples. For example, one person is applying for a visitor visa, let's say to attend a funeral of a close relative, or somebody near and dear is in the hospital. Well, the next person in line at the embassy is applying for a visitor visa to go to Disney World. Now, in some cases, the person applying for a visitor visa to attend a funeral or visit a sick relative is refused the visa, but the person wanting to go to Disney World is approved. Well, how can that be? Well, it may be that the person wanting to attend the funeral, let's say, is unemployed or has a low-paying job in their home country. Perhaps all their family is already in the U.S. and they may be the last one left behind. And if they are able to get to the U.S., they could perhaps work as a caregiver and earn far more than they could in their home country. So it looks like they might have a strong incentive to remain in the U.S. On the other hand, let's say the person who wants to go to Disney World may be living in Forbes Park, which is kind of like the Beverly Hills in the Philippines. Or, they may be living in Dubai and they drive a Bugatti and they are extremely wealthy with lots of housekeepers. Well, obviously, the first person, the one wanting to attend the funeral, might be tempted to overstay, but the wealthy person has a strong incentive to return to their home country after visiting Disney World. Now, I want to be clear. I'm not saying that only wealthy people are eligible for visitor visas, but you do have to demonstrate that you have a strong reason to come back to your home country or residence abroad after the visit, and you don't have a reason to be tempted to overstay or remain in the U.S. Therefore, when applying for a visitor visa, it's really not why you want to come to the U.S. that's important, but instead, what makes the consul satisfied that you have a strong reason to return after your visit. Therefore, if a person is under petition, but let's say the priority date is still years away, let's say they've been petitioned by, let's say, a brother or sister, and it's still 15 years or more before the priority date is current, and they still have a good life in their home country, they could probably prove that although far in the future they will immigrate, right now they have no immediate plans to do so. Instead, it looks like they will visit the U.S. and they will come back. They can demonstrate that their intent for this trip is just to visit and to return to their residence abroad. And the same analysis applies if a person, let's say, already has a visitor visa and now they're under petition and they plan to visit the U.S. They would also have to demonstrate to the immigration officer at the airport that although they may be under petition and they plan to immigrate in the future, they do not intend to do so on this visit. I know it can be confusing and frustrating for people when applying for visitors' visas, especially when they are under petition. But as you can see, the regulations do allow people to be issued visitors' visas even if they are under petition, provided that they can prove they have no present intent to immigrate. It's also important when filling out the visitor visa application, the DS-160, that you answer truthfully, because there is a question there asking whether the person has a petition filed on their behalf. If that is the case, of course you have to answer yes. If you answer no and it's discovered, you could possibly have your application refused or even be charged with fraud. Well, I hope you have found this video informative and that I have cleared up some of the confusion about, first, eligibility for visitors' visas and eligibility to apply even if you are under petition. And I will continue posting other videos, of course, which I hope you will find informative and helpful to you in connection with all of your immigration questions and concerns on a wide variety of immigration topics. So, it's important. Make sure that you like, share, and subscribe to this channel. I'm Michael Gurfinkel, and thanks for watching U.S. Immigration TV.